Hello, and welcome to Part 2 of CPCS Investigation. This is Constitutional Fraud, and I'm your host, William Toppi. In this episode, we'll meet the third attorney tasked with scrutinizing my case and evaluating Deborah DeWitt's actions as my appointed counsel. We'll delve into this attorney's professional assessment, which unequivocally deemed all my claims entirely without merit. In our previous episode, we explored how, shortly after my release from prison and the commencement of my second sentence, 2 years of probation on count 1, breaking and entering, I reached out to the CPCS. It was 3 months after my release when I sought their assistance in comprehending the events that unfolded in court. I was convinced that something was profoundly amiss during these proceedings, as I felt coerced and tormented into pleading guilty, despite my continued assertions of innocence. If you've been following this series, you know that my ultimate goal is to petition the Massachusetts governor for a pardon, seeking justice for this fraudulent conviction and the unjust stigma it has imposed upon my life. In Part 1 of this episode, we delved into the initial investigation led by attorney Aviva Jeruchim, a supervising attorney at CPCS, not to mention one of Boston's top criminal defense attorneys. We also explored the second attorney appointed by CPCS for the case screening, Ann O'Reilly. However, at the end of my first year of probation, Ann O'Reilly withdrew from the case, and shockingly, Attorney Jeruchim concluded that all my claims of fraud committed against me were utterly false and devoid of merit, all despite the undeniable evidence that told a different story. In the second year of my 2-year probationary period, yet another attorney, Stacey Gross-Marmor, was appointed to screen my case. The fact that CPCS assigned a third attorney to review the case, even after the conclusions from the supervising attorney, remains an enigma in the realm of Massachusetts CPCS proceedings. Nevertheless, Gross-Marmor's assessment referred to Jeruchim's findings. As we explored in Part 1, by now I had obtained the lobby conference waiver of rights and sentencing colloquy. Armed with this crucial document, I came to realize the shocking truth. My specially appointed counsel, Deborah DeWitt, was not listed among the appointed counsels. Instead, she was a board member of CPCS in Middlesex County. Disturbingly, I discovered that she had actually interrupted the court proceedings to assign a false history category level to my criminal record, setting a deceptive sentencing starting point of 2.5 years, as opposed to the recommended 2-year sentence according to the sentencing guidelines. The truth revealed that she mentioned a plea agreement even before conducting any negotiations regarding the terms and conditions of the case. More alarmingly, she made personal sentiments a part of the courtroom equation, expressing her deep offense over an accusation that I kicked a dog during the crime due to being a dog owner herself. This revelation only intensifies the fraudulent nature of the case. DeWitt, in fact, committed perjury by referencing her own suppressed evidence, falsely claiming that a witness had seen a Facebook photo of me that the police were unaware of. This was a stark contradiction to her own suppression motion, which correctly stated that it was the police who had presented the witness with the Facebook photo, further underscoring the blatant fraud she perpetrated upon the court. DeWitt's assertion that I committed the crime due to drug-related factors stemming from a possession of 3 Valium pills without a prescription 3 years prior, and a drug trafficking conviction from over 2 decades ago, revealed her unprofessional bias and judgment. Even more disturbing was her failure to challenge the judge's misleading statements to me. Instead, she allowed the judge to deceive me about following the sentencing guidelines, when in reality, he was adopting the false history category level she had introduced, and imposed a committed sentence on count 2 instead of count 1. This violation of established rules and imposition of a unique, unprecedented, and disparate sentence marked a dark moment in Massachusetts judicial history. As we venture into Part 2 of CPCS Investigation, we find ourselves in the midst of my second year of probation. It was on January 2nd, 2017, when I first received a letter from Gross-Marmor notifying me of her appointment to investigate my plea withdrawal request. I recounted to her the same harrowing tale I had shared with the previous investigating attorneys. I detailed how I felt tortured and coerced into pleading guilty. The torment included multiple transports to court and a transfer to the Billerica County Jail, where my wife's boyfriend worked, who was an alleged victim of the dismissed case. This ordeal followed a period of being on a suicide watch and enduring punishment in solitary confinement with a complete stranger, a week that encompassed Thanksgiving. I then found myself repeatedly transported and transferred, and then transported and transferred again. The breaking point came when, on the day of the plea, DeWitt informed me that she lobbied the case in my absence. She made it clear that if I didn't plead guilty that very day, I would be sent back to either Billerica, where I feared for my safety, or to Plymouth, where I had already spent an agonizing year waiting for a trial date after refusing to engage in any negotiations. My determination for a fair trial was met with the disheartening revelation that DeWitt couldn't secure a trial date for another 6 months. In the eyes of the law, these experiences undoubtedly and unequivocally constitute torture. However, it is both surprising and suspicious that none of the investigative attorneys acknowledged this claim in their conclusions, nor did they acknowledge the indisputable evidence supporting these events. Gross-Marmor took a significant step by filing a motion that retained the transportation records, which serve as crucial evidence of the tumultuous movements I endured. These records definitively proved the authenticity of these events, leaving no room for doubt. During this time, I was physically present in court when Judge Heidi Brigger officially appointed Gross-Marmor to represent me for appellate action. This appointment is meticulously documented in the court's docket. In essence, this action should have put an end to the need for further screening to ascertain whether my claims warranted the appointment of counsel. The court, through its own direct appointment, had seemingly confirmed the necessity of representation. However, as you'll soon discover, this seemingly definitive decision was quietly undone without my knowledge, inexplicably returning me to the waiting game as I anticipated the screening process to determine whether I would be granted counsel for post-conviction motions. The catalyst for this change was the long-awaited restitution hearing, which we'll delve into in our next episode. This was just yet another layer of deception in this intricate and confounding tale. The critical argument has evolved beyond the question of whether or not I received effective legal counsel or if there was judicial bias. Instead, the focus of my contention is whether the legal proceedings adhered to the law. The irrefutable evidence overwhelmingly attests that they did not. There is no room for doubt. A harmful systematic error occurred, tainting the conviction and warranting a new trial. This conclusion hinges on two distinct facts. First, we have the unequivocal proof that defense attorney Deborah DeWitt intentionally employed her own suppressed evidence against her client while he was absent from the proceedings. She deceptively stated that the police had not presented this evidence to the witness, whereas her own affidavit shockingly contradicts this by confirming that it was indeed the police who showed the evidence to the witness. This deliberate act amounts to perjury and an outright fraud upon the court, both of which are criminal offenses designed to manipulate the legal process. This constitutes a treasonous act against the United States and should not be tolerated, but must always be prosecuted. It's worth emphasizing that the argument has now shifted from focusing on the guilt or innocence of the crime in question to a more fundamental issue, the integrity of the legal process. The evidence unequivocally establishes that the proceedings were conducted unlawfully, making the demand for a new trial indisputable. The second compelling fact we must confront is the behavior of Judge David Ricciardone in this case. There is no room for dispute. The judge egregiously violated the defendant's constitutional rights by using deceit to extract their waiver. The evidence is overwhelming. Ricciardone explicitly assured the defendant that he was following established guidelines, only to then proceed to directly negotiate the terms of the sentence with the defendant himself in open court. This not only breached the rules of procedure, specifically Rule 12, but also constituted a gross act of perjury and a blatant fraud upon the court, occurring right within his own courtroom. This egregious misconduct involved the complete abandonment of the sentencing guidelines he just claimed to be following, leading to the imposition of a disparate sentence unprecedented in the legal history of Massachusetts. This treasonous act fundamentally renders the defendant's plea unknowing and involuntary, laden with harmful systematic error that cannot be justified but must invariably be prosecuted. Such actions constitute a treasonous assault against the United States, undermining the core principles upon which the justice system is founded. It is these concrete and undeniable facts, captured within the unwavering court records, that unequivocally necessitate the appointment of counsel by the Massachusetts CPCS. The gravity of these revelations further demands the imposition of criminal charges and sanctions against the attorney who engaged in this illegal scheme, and immediate repercussions for the judge involved. This clear-cut miscarriage of justice underscores the urgent need for a new trial for the defendant and accountability for those involved in such blatant acts of misconduct against our justice system. However, the distressing reality lies in the contrasting outcomes. After the CPCS investigation's conclusion, while my case was still pending and I remained under the threat of 10 more years of imprisonment during my extended probation, DeWitt was bestowed with the prestigious Honorable Paul A. Chernoff Servant of Justice Award in July of 2018. This award was given despite her treacherous criminal acts against the judiciary. On the other hand, Judge David Ricciardone will finish his distinguished career before retiring from the judiciary, taking on a role at Central Mass Mediation and Arbitration, CMMA Neutral. Meanwhile, the consequences for me continued to unravel, threatening me with probation violations and a return to prison, even when my probation extended for another year, maintaining a persistent threat, casting a long, looming shadow over my life. Now let's take a look at the findings that left me without any assistance from the Massachusetts Committee for Public Counsel Services. On September 27, 2017, attorney Stacey Gross-Marmor wrote this 10-page findings, her conclusion. I'm not going to read it all. I'm just going to read two parts that pertain to my claims of fraud upon the court by both the defense attorney, Deborah DeWitt, and the acting judge, David Ricciardoni. This is addressed to Donald Bronstein, the Director of Criminal Appeals at the Committee for Public Counsel Services. Dear Attorney Bronstein, I have been assigned to review the above-captioned matter to determine whether Mr. Toppi would benefit from a lawyered post-conviction proceeding. My review of this matter included meeting with Mr. Toppi, review of the plea hearing transcript, multiple conversations with trial counsel, communication with the district attorney's office, review of the trial counsel's file, review of predecessor screening counsel's file, review of all discovery and pretrial motions, a review of the trial court docket, and review of both the Plymouth County Sheriff and Middlesex County Sheriff's transportation records. Based upon my review and an investigation into this matter, it appears that there are no meritorious issues not previously presented to the court. Accordingly, for the reasons outlined below, I recommend that Mr. Toppi be advised to proceed pro se at this time. Talks about the factual background. This is the only thing she mentions about Judge David Ricciardoni's deception in eliciting my waiver of rights. On December 17, 2014, Mr. Toppi, following a lobby at sidebar, pled guilty to both the breaking and entering and larceny charges. This was a disparate plea. The Commonwealth requested the court sentence Mr. Toppi to 3 to 5 years in state prison. Mr. Toppi requested the Commonwealth sentence him to 1 year, time served. Following Mr. Toppi's plea, the trial court sentenced Mr. Toppi with regard to the larceny charge to 2.5 year state prison sentence, and with regard to the breaking and entering charge to a 2-year probation sentence to be served on and after the above committed sentence. In addition to the standard conditions of probation, it was ordered that Mr. Toppi undergo substance abuse treatment as deemed necessary and that he pay an amount of restitution to be determined at a later date. She goes on to discuss various reasons why, about talking about ineffective counsel and a person's rights. Her last issue is the DeWitt's committing perjury and fraud upon the court, and this is how she dealt with that. And sixth, Mr. Toppi's claim that trial counsel was ineffective because during the lobby conference she referenced a photo identification which was suppressed is without merit. Review of the trial court docket indicates that on July 11, 2014, a motion to suppress photographic identification evidence was filed. However, this motion was never acted upon by the court. She then repeats everything that Aviva Jeruchim stated in her conclusion. And her final conclusion is, for the above stated reasons, I recommend that Mr. Toppi be advised to proceed pro se at this time. As always, should you have any questions or wish to discuss this matter further, please feel free to contact me at any time. Very truly yours, Stacey Gross-Marmor. That was September 27th. On October 3rd, 2017, I received this letter from Donald Bronstein, the Director of Criminal Appeals at the Committee for Public Counsel Services. It states, Dear Mr. Toppi, Massachusetts law does not provide you with a right to have an attorney appointed to represent you in the proceeding currently before the court. However, an attorney from the Committee for Public Counsel Services, CPCS, Post-Conviction Collateral Screening Panel was assigned to review your case and inform me whether your case presented circumstances that would warrant my assigning counsel, despite your not having a right to a lawyer. The attorney assigned to review your case has advised us concerning the history and current status of this proceeding. We have decided not to assign a lawyer to represent you. If you wish to proceed pro se, you may request a copy of the self-help materials in writing from Dorothy Melly at the above address. I regret that limited resources and legal requirements restrict the availability of legal assistance our office can provide you. You can't even begin to fathom the sheer disbelief that coursed through me upon receiving these conclusions from the Committee for Public Counsel Services. I was left utterly speechless and overwhelmed. I was now left with no choice but to navigate the intricate legal landscape as a pro se litigant, filing a Rule 30 motion to the very court presided over by the very judge who deceived me with false pretenses. Until next time, I'm your host, William Toppi. As always, remember, our journey towards justice begins with you.